Number 75, People v. Donna Jordan.
Good afternoon. May it please the court, Sarah Cohen on behalf of appellant Donna Jordan. I'd like to save 3 minutes for rebuttal.
Yes.
And I'd like to address both points in my brief, beginning with point one. In this one witness identification case, in which Donna Jordan was 20 years older and half a foot taller than the description of the suspect, the people introduced evidence that Ms. Jordan's DNA was on a phone left behind at the scene, without calling a witness who performed, witnessed, or supervised the critical portions of the DNA testing, and this violated the Confrontation Clause.
So they said this was a witness who reviewed the raw data, right? That was their claim, that this was the appropriate witness under Sean John. So what, in your view, would that entail? If you really did have the right witness who independently reviewed the raw data, what does that mean?
So in order to independently review the raw data, this requires looking at the unedited electronic data, which needs to be viewed using computer software. This is different than the printed graphs that appear in the OCME files, because it can be viewed in much higher resolution with the computer software, allowing the analyst to zoom in, zoom out, and otherwise manipulate and edit the data, including removing labels before that printed version that appears in the OCME files, which is what the analyst reviewed in this case.
How do we know that?
That's what he reviewed in this
That
case?
he didn't review it electronically.
Yes, and so if I could address each of the samples separately, because there's the swab from the phone and then the buccal swab. The swab from the phone, he testified that he was the technical reviewer, and he never mentioned raw data with regard to the phone. He said that he reviewed his conclusions were based on his review of People's Exhibit 16, which is the OCME file, and that exhibit did not include the raw data. So if
Is the software program STR Mix, is that what it's called?
No, that's a different software program. So the software program where you view the raw data, it's Gene Marker in this case, or Gene Mapper in other cases. StarMix is a different software program where the final edited profile is entered into StarMix in order to do the match, typically.
I see.
So although Coy's name appears on some StarMix paperwork in this case, it's not on any of the Gene Mapper paperwork, it's not on the edit tables, not on the control tables.
And you're convinced this expert did not look at the Gene Mapper output, the raw output?
He did not. So to look at the raw data in using Gene Mapper, you need to look at it using the software, and he didn't do that. For the phone swab, he admitted he didn't do it. He said he was not there when the person was inputting it into the computer, and that's on page 240.
So is the natural conclusion of that statement that the testifying expert was relying on editorial choices that had been made by the person who examined, it's the electrophoresis portion, right?
Yes.
By the person who did the original electrophoresis
Exactly,
analysis.
that's correct. And that can be seen in the edit table in this case, which shows that 3 edits were made by the analyst using Gene Marker to look at the raw data. They deleted the labels on 3 peaks, and then that information was not included in the printed electrophoregram that Coy looked at.
If that analyst is not available, the analyst that initially does that to testify at trial, can someone else perform that task again?
Yes.
And is that because whatever the file is saved? How would you do that?
Exactly. So if the person who performed the initial review of the raw data is unavailable for trial, another analyst such as Coy, all he would need to do is go to the computer terminal, and using the software, he can review the raw data, which is saved. So he would not need to redo any of the physical testing. He simply needs to conduct his own independent analysis.
So you don't need to still have the actual sample
You do not. You do
around.
not. It's all saved. The files are saved.
And what about with respect to the second swab where he was the reviewing analyst?
Yes. So with respect to that swab, and the people cite this in their brief, he did make a remark to the effect that he reviewed the raw data. However, when defense counsel asked him follow-up questions to try to understand what was he referring to and what did he actually do, this clarified that he actually did not look at the unedited version of the raw data. And I'd point the court to page 263, where defense counsel asks, quote, "If I understand you correctly, someone else ran the raw data, did the work on it, and provided it to you, and you reviewed it, correct?" And Coy says, yes. So I think that's pretty dispositive, that although he made a prior statement that he reviewed the raw data, when he's questioned on what does he actually mean by this, he never viewed the unedited electronic version. And there's also, even in Coy's earlier testimony, about 20 pages earlier, when he's discussing in general terms the role of the report analyst or the interpreting analyst, he's always referring to the final data or the completed data. So on 241, he says, the reporting analyst goes through the completed data and draws their own independent conclusions. But that completed data is exactly what this court explained in John is not sufficient to meet the
So
confrontation
it's been
clause.
decided as a matter of law that that cannot be raw data. In other words, I was going to ask you originally whether there was some sort of scientific consensus over what the distinction is between raw data and edited data, but you basically, your last comment was, this has already been determined as a matter of law. Is that correct?
Exactly. John held that that is the critical portion of the DNA testing, is that the people must call an analyst who reviewed the raw, unedited data before these edits were made. So it's a straightforward application of John's standard for which analyst the people need to call.
Counsel, I
when
know
you s-
you're, oh, I'm sorry, you were first. Go ahead.
Just quick, when you say completed data, to make sure I understand, you mean the edited data, after the analyst has gone through and edited out any alleles that she thinks don't appropriately belong there?
Exactly.
So I understand you say that this wasn't done in any of the samples here, but hypothetical, if it had been done for the swab from the phone, and you had the right analyst, right, who went into the software and reviewed that raw data, would that be enough?
I'm sorry, could you?
If you just had that witness for the swab from the phone, right, where they developed a profile, that witness comes in, testifies, I went into this software and I did whatever needed to be done, and we agree. Okay, hypothetically, you did that in this case for the phone swab. Would that be enough?
That would be enough for the phone swab. So I think,
You would still, let's say you're just comparing it to the known swab, right, buccal swab. You would still have to call a raw data reviewer for the buccal swab as well?
exactly, yes. So this court in Austin and Cincilis, which were cases looking at a post-arrest buccal swab, held that you need to call the analyst who reviewed the raw data for the buccal swab. And in John, as well as Austin, this court explained that opinion testimony about a match would be inadmissible under New York law absent the proper foundation that each of the two profiles that the analyst is testifying are a match, that each of those profiles is reliable. So you'd need the proper analyst to testify for both samples. To address harmless error in this context, the people's case without the DNA evidence would have solely consisted of testimony from one witness that the robber was a woman in her 30s who was 5'5" to 5'7", who jumped over a counter and outran the 25-year-old store clerk. Ms. Jordan was nearly 60 years old. She was 6 feet tall. She presented medical evidence that she had chronic lung conditions and severe osteoarthritis in her hips. So without this DNA evidence, which, as this court explained in Wright, casts an aura of invincibility upon the people's case, this would have been a very different case.
And what do you say about the closing argument?
Thank you. Yes. The summation, the people's summation capitalized on the court's evidentiary rulings excluding evidence that would have been extremely probative of Ms. Jordan's defense in order to knowingly falsely argue to the jury that Ms. Jordan created a person and that she tailored her testimony to the people's case.
Is that based on, the photograph was allowed, but the pedigree information was redacted?
Right, so what the court allowed was a cutout photograph showing only Alicia Redfern's face, but without her name or her height or any information that would show that the person in this photograph was Alicia Redfern.
And is it correct that the prosecutor suggested that the defendant made up Alicia Redfern?
Exactly. The prosecutor repeated in summation this term that Ms. Jordan was a creative person, that she was literally creative because she created a person, Alicia Redfern, and that this person happened to be the same height as the description provided by the complainant.
And the fact that he knew that there was a police record with
Yes.
her actual information, is that misconduct?
Absolutely. It violated his duty not to knowingly advance false positions before the jury. And it resulted in a trial that was skewed in the prosecutor's favor and with the jury having a distorted impression of the truth. Ms. Jordan was prevented from introducing a video, a Mirandized statement that she gave on the day of her arrest, in which she maintained that she never entered the store and that Alicia Redfern was the robber. And she's prevented from introducing certified records that would have established this. Defense counsel preserved this issue by objecting multiple times throughout the prosecutor's summation, although any attempts to create a more thorough contemporaneous record were frustrated by the prosecutor, who, as the trial court noted, kept rolling through the summation and did not pause for the court to rule on objections.
What about the suggestion that his claim was so outrageous, of course, the jury didn't believe it, his comments?
That suggestion has no basis in any of this court's law. This court has consistently held that when the people misrepresent evidence, that will not be upheld by this court, that the prosecutor has a duty to refrain from improper methods calculated to produce a wrongful conviction. So that, combined with the fact that the jury never had the chance to consider the objective evidence of Ms. Jordan's defense, deprived her of a fair trial. Thank you.
Thank you.
Good afternoon, Your Honors. William Brannigan for the Office of District Attorney Katz. May it please the Court. Your Honors, first to the original swab of the telephone. The reason why that swab was not precluded by the Confrontation Clause is because it was taken before there was a known suspect in this case, and the primary purpose...
You didn't raise that as a basis for getting the evidence in at trial. You raised that you had the proper witness, right?
Your Honor, we did argue the proper witness, but the objection was made under this Court's precedent in Sean John and in Austin, and the first thing that the defense needs to establish is that it's testimonial. Those cases both address these issues, and both cases distinguished cases like this one where the suspect was still at large when the original sample was tested. And because of that, and because...
Do you agree with your opponent's characterization of what raw data is?
Your Honor, there is some problem when we discuss raw data because it is used differently in different cases.
How do you
but
think we
basically-
meant it?
Well, okay. So first of all, when the DNA is fed through the machine, the initial data is indecipherable and a software program's applied. So what comes out of that, which is basically a series of color-coded graphs that are stored in the OCME computers, that is the raw data, as I think this court has understood it. So to the extent, yes, to the extent counsel has argued that, I agree with that. So,
Is there anything in the record that shows that this witness performed that step or redid that step in conformity with this understanding of raw data, consistent with that?
Your Honor, under the record here, only for the second swab. The first swab, he was the final technical reviewer, and he reviewed all the evidence in this case, and he did testify that he came to his independent judgment as far as what his conclusions were when he testified at trial.
Can you come to an independent conclusion if you're not looking at the raw data? That seems to undermine the independence of the conclusion.
No, Your Honor, you can come, now, again, I understand I have an issue with Sean John with this, but yes, you can come to an independent conclusion if you look at all the data as he testified that he did as the technical reviewer in the first instance.
What is it that he's reviewing? I'm over here.
Your Honor, well, in that case, he's reviewing basically all of the documents that went into compiling the final
So
the
he's
final
reviewing
case.
everything post going through the machine and whatever judgment calls, maybe based on the material
Yes, Your
that
Honor.
goes in the report. So again, it does seem, again, odd to say that's an independent review when it's building off something else that's already embedded with judgment calls.
Yes, Your Honor, again, he did testify, that was his independent judgment.
Again,
Can he
he said
see-
those words, "It was my independent judgment," but his testimony is problematic in the sense that he keeps saying "we," and I don't know if the "we" means he and another analyst in this case, or the "we" means the entire entity that's doing the testing. Again, this imprecise language doesn't really lend itself to us making an analysis of what he was looking at specifically, what he did. I can't tell what he did, because he kept using "we" and "I" interchangeably and at different stages.
Your Honor, he did testify also, he was the technical reviewer in this case, he had the responsibility for making a final account of the case. That's as to the first swab. As to the second swab taken post-arrest, again, that was not objected to at trial, but as to that swab, he testified that he received the raw data, and what he described, the way that he described it, he was receiving that original information, and then he put it into document form. I think he testified that he...
Sorry, just so I make sure I have your point on the swab of the phone. If we were to say that's testimonial, you don't think, you agree you didn't bring the right witness, is that right?
I agree with that, Your Honor, but I think in order for this court to hold that that's testimonial, you cannot splice that this is testimonial from the primary purpose test, just like you can't splice, for instance, a Brady test. The court has to make a decision on whether that testing done before there's an apprehended suspect was testimonial.
What do you say with respect to the summation of the prosecution?
Respect to the summation, the claims at issue here were wholly unpreserved. It wasn't just that he didn't object contemporaneously. He had an opportunity to object before the charge, and he failed to do so. He also had an opportunity to object at least before the jury started to deliberate.
So you say that it's not preserved, that the prosecutor suggested that she made up this witness?
That's correct, Your Honor. And if the defendant had preserved in this case, there
And
were...
if she had, assuming she's preserved it, were those proper statements for the prosecutor to make?
Your Honor, created was simply wrong. She did not create a person. When asked about this, he said he basically meant that she created the fact that she was at the scene committing the crime.
What about
But it-
the characterization that the prosecutor wasn't even listening to the court, just rolled on through?
Your Honor, that's what the court said. That's what the court said. The problem with that, as far as the preservation in this case, or creating an exception for the preservation in this case, is that there was no argument made after the summation was finished. There was no argument made before the charge when this could have been cured. He waited until the jury had already started deliberating, and that's why these issues are outside the court's jurisdiction.
And so going back to the buccal swab, is there anywhere in the record that we can tell whether the analyst looked at the raw data before it had been edited and then compared it to the edits and verified that the edits were done correctly? Is there anything we can point to determine that?
Your Honor, for the second swab, you can look at the record in his testimony regarding the fact that he received the raw data and he conducted his independent review and said he was in charge with creating the report. So that final report in the file, which has created an issue, for the first swab and in other cases, but that's where those final edits appear. That's where you see the edits and that are then introduced.
You see the unedited and edited data, raw data?
Well, he's receiving the raw data is the raw data. So in this context, when he says raw data, I think the plain view is that he has received the original data without edits. Your Honor, if the court has no further questions, the people rely on the brief.
Thank you.
Counsel, what do you say with respect to the claim that your client didn't preserve the prosecutorial misconduct with respect to the summation?
In addition to his contemporaneous objections throughout the summation, defense counsel immediately after summation was over moved to make a record about the summation, which the court said was preserved. Subsequently, defense counsel made a detailed mistrial motion where he raised a majority of the issues that are before this court today, including the prosecutor's comments that Ms. Jordan created a person, that she tailored her testimony to the people's case. The court denied that mistrial motion on the merits. The court noted that these cases tend to be reversed, told the prosecutor that he went overboard and needed to temper his comments for the next trial, but nonetheless denied the mistrial motion. Well, the court was wrong to use Ms. Jordan's trial as a teachable moment for the prosecutor.
If we agree with you about the DNA evidence, do we have to even reach those issues?
No, they're both new trial issues, so no. If the court grants a new trial with regard to the DNA evidence, I don't see why the court would need to reach the other issue. Thank you.
Thank you.